I'm an attorney in the Sacramento area, although I do practice in most counties in California. I am a trust and estates attorney, and I pretty much exclusively, since becoming an attorney, have practiced in the areas of estate planning, such as wills, trusts, powers of attorney, conservatorships, and also anything related to estate or trust administration. I also have quite a bit of experience in dealing with ACC in the past. So when I was in high school, growing up in the Pocket area, I did volunteer with ACC, and in more recent years, since I've been back in Sacramento, I've volunteered at some of their events. So you probably have seen me either bussing tables or passing out food at various food fundraisers. I'm also a vice president and secretary of the Sacramento Asian Sports Foundation, and I've been a board member with them since 2016. And as part of all of the introductions that I do with ACC, I always have to give a shout out to my mom. So if anybody happens to see Sue Chow at either ACC, Lewis Park, or Garcia Bend playing pickleball, make sure to let her know that her daughter did give her a shout out in this presentation. All right, so today we're really going to be talking about what you can expect if you were nominated as either a trustee, an executor, or an agent under various estate planning documents. All right, so first, let's talk about the different roles that we're going to be covering, because there's different terminology when it relates to the different estate planning documents. So it's really important that we're all on the same page about identifying what capacities you may have been nominated in, or if you yourself are considering doing estate planning documents, you may also be thinking about who you want to appoint in any of these positions. So first, we'll go over the term trustee. Most often, I would say, when clients call me or prospective clients call me, they somewhat, and not to their fault at all, but oftentimes they'll refer to a trustee as an executor, and that's not technically correct. Now, with a trustee, that's going to be someone who's been nominated to act regarding someone's living trust. And so with a living trust, that document would have been created by what we call either a settlor, grantor, trustor, someone who's created that document, and they've appointed you to act as a trustee. The next capacity would be as an executor, and that would be for a last will and testament. So a specific document, also an estate planning document. And then the third capacity that we'll be discussing today is an agent. So in California, we break up our powers of attorney into two separate documents. That's either going to be the durable power of attorney for finances and generally personal affairs, and the Advance Health Care Directive related to medical decision making. All right, so first, regarding a living trust. A living trust is really just a legal contract. So this document will provide instructions for control, management, and distribution of assets that are in a living trust. And really, the trust itself serves as the legal, what I like to refer to as a key, to the trustee, and provides them with access to assets that are funded into the living trust. When I talk about funding of a living trust, I've gone over this in a lot more detail in previous presentations that I've done for kind of estate planning 101 in general. But really, when we're talking about funding assets into a trust, that's going to be assets that are either titled in the name of the trust itself, or where the trust is designated as the pay-on-death beneficiary of those assets. And so it's really important to note that as a trustee, if you're dealing with a living trust, you really only have authority over those assets that have been funded into the living trust, or that may eventually be funded into the living trust. The next document, like I mentioned before, is the last will and testament. And generally speaking, a last will and testament can either be what I like to refer to as a standalone last will and testament, where the person who created the will, also known as the testator, will specify who the beneficiaries are and who the executor is who will administer that will. Now, I call it a standalone last will and testament because this would be if somebody created a will and they didn't create a trust at the same time. And the will itself really serves as all of the instructions for how assets should ultimately be administered upon their death. A pour-over last will and testament is slightly different. That type of document really just serves as a backup to the trust for any assets that weren't properly funded into the trust. So earlier I mentioned that we really want to make sure that assets are properly funded into a living trust. And if you're the trustee who's acting and for some reason there's an asset that's out there that didn't have a beneficiary designated, was not titled in the name of the trust, or that was not jointly owned with someone else, then you may need to then look to the last will and testament or the pour over last will and testament to possibly scoop that asset up and pour it over into the trust. And if you're also likely designated as the executor under that last will and testament, you may be acting in dual capacities in order to redirect that asset to the trust. All right. And the next document is what we call the power of attorney, or the durable power of attorney. And this document really allows someone, aka the principal, to appoint someone else, aka their agent, which would possibly be you, to act on their behalf regarding finances and other personal affairs. Now, it's really important to note that if there's no power of attorney in place and someone needed assistance, if the principal needed assistance from someone, let's say a spouse or a child, to help them with any of their financial or other personal affairs, that without that power of attorney, the default is typically going to be that they would need to go to court to get that authority. And that's mostly going to be related to assets, again, that are not titled in the name of a trust and that are probably only titled in the principal's name individually. Another really important piece that you should know if you're going to be acting as an agent under a durable power of attorney is that you only have the specific authority that the principal gives to you. So if anyone's seen a power of attorney before, it usually comes in a couple of different formats. It can either be one where the principal has initialed next to a bunch of different boxes outlining different powers. That's most often going to be our uniform statutory durable power of attorney. Or there can be a more long form specific power of attorney that really lists out all the different powers. And so only those powers that are presented in the power of attorney will be granted to the agent. And another important detail that I think a lot of people miss when they're looking at powers of attorney is that they can also only do those actions that the principal themselves could have done. So for example, if you see in a power of attorney that the principal has given an agent the ability to manage a business, but the principal does not themselves own a business, then the agent, just because that power exists, doesn't necessarily mean that they have the authority to then all of a sudden start running a business on behalf of that principal. All right. And then the next document is the Advance Health Care Directive. So that document allows someone, again, the principal, to appoint someone else, the agent, to make medical decisions for them and to correspond with their healthcare providers about either their medications or treatment or any other needs that may come up. Now, again, when it comes to a power of attorney, their principal themselves is the one who should be making all of their own, whether it's under the durable power of attorney for finances and personal affairs, or it's an Advance Health Care Directive. It's really important that the principal is the one who's making all of their own decisions until either they can't make those decisions for themselves anymore, or depending on what authority they've given to their agent under their powers of attorney. I will say that with an Advance Health Care Directive, one common misconception that I get from clients is that they assume that the Advance Health Care Directive is actually a DNR, or a do not resuscitate form, and it's not that type of document. That would be more done with your physician or something that you would do directly with your physician. So really the Advance Health Care Directive serves a much more specific function of saying who it is that you feel comfortable making medical decisions for you if you yourself are either incapacitated or unable to tell your healthcare providers what types of treatment or withholding of treatment you prefer. All right, so big question that I always get from people is, when is it time to act? So you may be aware that you've been nominated in some documents to either act as someone's healthcare agent or power of attorney agent, or trustee, executor, right? Any of those capacities. But just because you've been nominated or named in those capacities doesn't necessarily mean that you have the immediate authority to do anything with those documents or to step into those roles. Now, it's going to be a little bit different depending on whether you're a trustee, an executor, or an agent. So when we talk about a trustee, the time that you would act as a successor trustee is typically going to be upon the incapacity, resignation, or death of a prior trustee, including possibly the settlor, grantor, trustmaker, the person who created the trust. One additional time where someone may act that I don't have listed there is that it's not uncommon where I'll have clients who will want to name their adult children as current co-trustees with them. So it's also possible that you could be acting in the capacity of a trustee right away when a parent or a spouse or someone else creates a living trust and names you as a trustee. When it comes to acting as an executor, you are really only nominated as an executor, and that authority only potentially becomes effective upon the death of the person who created the will, or as we've referred to before as the testator. Now, whether or not you actually need to be appointed in that role depends on whether or not a probate administration is necessary. So we'll talk a little bit more about that in a little bit, and I have talked about that in previous presentations as well. And now when it comes to an agent, whether it's under a power of attorney for finances or an Advance Health Care Directive, that's typically going to be authority that vests either immediately upon execution of the power of attorney document itself or only upon the incapacity of the principal. And we call this a springing power of attorney if it's only upon incapacity. So it's really important to identify at what point any of those capacities, or at what point you're going to step into any of those capacities. Now, I will say that any time where you might be stepping into the role of either a trustee or an agent due to the incapacity of the settlor or the principal, it's really important that you review the trust or the power of attorney documents themselves, because typically there's going to be very specific instructions for what you need to do to prove the incapacity of that person whose role you're stepping into. So for example, when it comes to a trust, it's pretty common that there will be language that says that the settlor is deemed incapacitated or a previous trustee is deemed incapacitated only if either one or two physicians have evaluated them and given a written statement that they are unable to manage their own finances. And for medical side, it may also have the same requirement where they are unable to make their own medical decisions or manage their own medications, things like that. So really important to make sure that you know exactly what the triggering authority is for you to step in, because I will say that I've had people come to me before and somehow were able to start acting right away, even though they actually didn't have the authority to do that. So real important to make sure that you're acting within the bounds of what you're allowed to do. All right, so what next? For each of the different documents, it's really going to depend on when you need to step in and the specific steps that you need to take that are next. Now, let's say with a trust, you step in either during the lifetime of the person who created the trust or after their death. No matter what, your first step is you're always going to want to review the trust, potentially depending on how many beneficiaries are, but for the most part, you will have to do what's called a notification by trustee, which is a very specific form that's specified in the probate code and has information in there that says what your name is, how you can be contacted, and that you have accepted the position of trustee. And you normally have to provide that to very specific individuals depending on what time you're stepping in as the trustee. It's also really important that you consult with a tax advisor, and I probably should have also included in here that you should probably consult with an attorney as well regarding what your ongoing duties and responsibilities are. And then you also want to make sure that you're inventorying and potentially marshaling or getting control of all assets that are in the trust. So I mentioned before that there's that really important piece of funding of assets into a living trust. And so part of what your responsibility as trustee is to identify what all the assets are that have been funded into the trust, and possibly what assets you may need to move forward and claim on behalf of the trust to fund the trust with. And then finally, it's also really important that you identify any and all debts that might be associated with either the settlor or their estate that may need to be settled. And one really important piece that I should point out is that with a living trust, this can all be managed privately, assuming that the person who created the trust had everything set up ahead of time and made sure that assets were either properly funded into the name of the trust or that there weren't assets that were basically just left in their name individually with no beneficiaries designated or no joint ownership. So I do want to give an example of a pretty typical situation where I have clients come in and they are seeking advice about what they need to do as a trustee. So let's say hypothetically, mom created a trust and designated her oldest son to be the successor trustee. Mom has since passed away, and mom doesn't have a surviving spouse and has 3 children. So her oldest son and then 2 other children, right? So in this scenario, son comes to me and says, mom passed away. I need to know what I'm supposed to do with this legal contract, this living trust that's full of a ton of legalese, and I just want to make sure that I'm doing everything correct because I know that this can get complicated and I don't want to make any mistakes. And so hats off to whoever that person is who comes to me, because it's not uncommon that people think that they can do it on their own, and maybe they do it perfectly fine and sometimes they make mistakes. So it's always better to get some advice. But in this hypothetical situation, son comes to me. And so what we do first, of course, is number 1, review the trust. So we review the trust document, we go through it, make sure everything is valid, that it was executed properly, that we look through to see if there were any amendments that were done later by mom, or whether there's anything else that we need to be aware of that might affect the way that the trust is going to be administered. So we look at that and we say, okay, great, son, I do see that you are listed as the successor trustee and that you actually do have authority to step in. I want to always confirm that they actually do want to accept that position, because you're under no obligation as a successor trustee to have to step into that role. You really do have to formally accept that position first. And the moment that you do accept that position, then you're taking on all those duties and responsibilities related to the trust administration. So we look at that and we say, okay, we confirm that you are the successor trustee, you're going to be accepting that position, and we do confirm that you and your 2 siblings are going to be the equal beneficiaries of everything that mom left behind, which is okay. That's great. Let's move on and see what are the next steps, right? So then we look, okay, number 3 on that list, you have to do a notification by trustee. And so the successor trustee, or my client, would then have to give notice to their 2 siblings of the trust that's been administered, that they are the ones who, or the one who has accepted the position to act as the trustee. And then also provide, I typically recommend that they provide a full copy of the trust and any amendments so that everyone is on the same page about what their interests are. Another function of sending out that notification by trustee is that if it's an administration post-death of the person who created the trust, that also starts a 120-day contest period, so that if any beneficiaries want to contest the trust, they're limited to that 120 days in order to do so. I won't get too much into no contest clauses and their effects during this presentation, but generally speaking, that notification does kick off that 120-day contest period. Next on that list then is that we'll want to consult with a tax advisor. So I typically recommend that the client either reach out to whoever the tax advisor was that their mother used in the past, so that they're aware of and familiar with all of the prior tax filings. And the client would have to file the mother's final income tax return, identify whether there's any estate tax issues, and possibly have to obtain a separate tax ID number for the trust, because the moment that mom passed away, that trust became irrevocable, and therefore you do not use mother's social security number any longer as an identifier or a tax identifier for the trust assets. So really important that they talk to a tax advisor and get that specific tax advice. Next, what he would have to do then is just inventory and marshal all assets. So in this hypothetical, let's say there's a house, a bank account, and a car, which is pretty common. So he would have to make sure that the house was actually titled in the name of the trust. You can just go to the recorder's office and double check what the most recently recorded deed was. And typically we would do an affidavit if it was titled in the name of the trust to remove mom's name as the trustee and now put son's name on as the current trustee. Now, this is not to be confused with actually giving son ownership of the asset. Really just he is being put on in a fiduciary capacity as the trustee so that he can then sell the property or transfer the property according to his mom's instructions under the trust. Other than the house, he would also double check to see if the bank account was titled in the name of the trust. Now, assuming it was, he would go to the bank and complete their paperwork to be put onto that account as well as the trustee and take control of that asset. And then with the DMV, he'd have to deal with the car through dealing with the DMV, and that's typically going to be through a non-probate transfer process because most people don't title their vehicles in the name of their trust. And then finally, he would have to identify any and all debts. So typically there's going to be some outstanding credit card bills, maybe some utilities that need to be paid for the house, and just make sure that he's settling all of those debts. Generally speaking, there is a 1-year statute of limitations after someone has passed away for any creditors to initiate formal claims proceedings to collect on any debts. But depending on the terms in the trust, the trustee may be required to settle all of those debts upon stepping in and acting as the trustee. All right, so what next if you're nominated as an executor? So like I mentioned before, whether or not probate is going to be necessary is really going to dictate whether or not you actually have to be appointed formally to act as the executor under a last will and testament. So there's really going to be two different scenarios here. One of them is if there was a trust, first we have to determine whether probate is necessary. And if there was no probate that was necessary, there is a requirement under the probate code that the original last will and testament get lodged with the county superior court where the person resided at the time of their death. So if, in this case, we're going to keep using mom as a hypothetical, if mom had a trust and probate was not necessary because the house, bank account, and car could all be handled through the trust administration, then with the will, that's probably not going to have to be used and no probate's going to need to be opened. And so that original last will and testament would just get sent off along with an original death certificate to the superior court, and they pretty much just hold on to it forever. They just are a repository so that you know that that is where you can locate the original will if a probate ever is necessary in the future. Now, in a different situation, let's assume that there was no trust. So mom did not create a trust at all. So first, you're going to want to review the will and double check to make sure that you're actually nominated as the primary or the executor under the will. And in this case, let's assume that, okay, son is named and nominated as the primary executor. And now he needs to determine whether or not a probate is necessary. And so I've mentioned that a couple different times. Now, the way that we identify in California whether a probate administration is necessary is going to be based on the types of assets that were left in the decedent's name or in mom's name when she passed, and also the value of those assets. So the general rule in California is that if mom owned assets worth over $166,250 in value, which, hey, it's California, so of course they're going to have a super random, very specific number that's difficult for people to remember. But nonetheless, if her total combined estate is worth over $166,250 in value, and she did not own those assets jointly with someone else, and she didn't have a pay on death beneficiary for any of those assets, and they're basically all left collectively in what we refer to as her estate, then those assets will have to go through probate in order to be distributed ultimately to whoever the beneficiaries are under the will. And so in this case, let's just assume the will names son and the other two children as beneficiaries. In order for son and those beneficiaries to ultimately receive either the cash value of all of those assets or the actual assets themselves, son is going to have to initiate a probate proceeding. Now, I will say that if anyone has not dealt with probate before, it's a very different situation than if you were dealing with a trust administration. So whereas with a trust administration, the goal is that all of that is handled privately on much less strict time schedules and procedural requirements, the probate administration is going to be much more involved. It's generally going to take a lot longer, be much more expensive, and be a public proceeding. And so just a heads up or a forewarning that really nobody in that situation has authority to do anything on behalf of the estate, whether it's to refinance the property or sell any assets until a formal probate has been initiated. It's not uncommon for a hypothetical like the one we've been talking about where maybe mom's house has a mortgage on it, and the mortgage company has found out that she's passed away, and all of a sudden they're threatening foreclosure. That's a pretty common scenario of clients who will reach out to me. And so typically what I tell them is we've got to file as soon as possible, because until you've been formally appointed as the executor of the estate, then nobody has authority to really do anything on behalf of mom's estate. And it's likely that the mortgage company is going to completely ice you out, and they're not going to tell you any information, whether it's payoff information for the mortgage or any other alternative solutions for delaying any sort of foreclosure proceedings that they might want to initiate. So really important that that process gets started sooner rather than later. And once you do initiate a probate proceeding, I don't want to go too far into what you can expect for a full probate, but generally speaking, everything starts with an initial petition to have someone appointed, which if you're in Sacramento County, potentially can take up to 5 to 6 months to get a hearing date, depending on what the court's calendar is like and how quickly you can meet all of the procedural requirements. So it can be quite a while until someone's even appointed, until son in this case could be appointed to act on behalf of the estate. And once you do open up that process, you are going to also be opening it up to a formal creditor's claims process. And so there's a lot of little extra steps that are very similar to a trust administration, but which would have to be done in the public probate proceeding kind of setting that you as the executor would be expected to do. So for example, you're still going to have to inventory all of the assets, but you're going to have to use what's called a probate referee in order to formally appraise certain assets. In this hypothetical case we've been talking about, the house and the car would have to be formally appraised by the probate referee. And then if mom had any outstanding medical bills or credit cards that hadn't been paid off yet, then son would also be required after appointment to give formal notice to all of those creditors, even though he would have been required to do a general publication of notice, which serves as a general notice to any potential creditors. Upon appointment, he would have to give that specific notice to any known or reasonably ascertainable creditors. And then that opens up the door for them to put in a claim and try to get paid from the estate before everything closes up. And during that period, there's a few other procedural steps that have to be met. And then finally, at the very end, you have to do a final report and account. And so If everything has gone well, son and the other two siblings haven't been fighting at all, and everything's been, everyone's been on the same page and no one's been upset about anything along the way, then you can get to that final point where you submit a final report and account to the court, and then ask that all of the attorney's fees, any reimbursements to son as the executor, and finally any distributions get made to any of the beneficiaries. So it's a very lengthy process. There's a lot of steps that you as the executor have to take, and you have to make sure that you're doing them correctly because the court is overseeing that entire process. All right. So what next if you're named as the agent under someone's durable power of attorney? You're probably sensing a theme here, but as with the other documents, you're going to want to first review the power of attorney. And like I mentioned before, you're going to want to see what the actual powers are that you've been given. Now, this is again assuming that you're acting either immediately or the principal has been deemed incapacitated already. And so you have to decide whether or not you accept that position to act as the agent. And if so, then you would review the power of attorney and see what powers you could exercise. And really, it's going to be really important that you determine what the principal's needs are. In many cases, this can include things like paying bills, so identifying all the different ongoing bills that the principal is going to need and that they were paying or trying to pay during their lifetime, typically related to utilities, credit cards, phone bill, cable bill, ongoing credit card bills, property taxes, all of that. So you're really going to want to make sure that you're stepping in and identifying what all those bills are. You'll probably also have to step in and start filing their annual tax returns for them. And depending on the complexity of the types of assets that the principal owned, you probably are going to want to speak to a tax advisor for assistance with that. And it'll probably be easier for you if you do deal with the tax advisor that the principal was using in the past. You're going to want to make sure that you're up to date on all of the insurance, because what you would not want to have happen is you step in as the agent and you stop paying either the property tax or let's say the homeowner's insurance on the property, and something happens where the house burns down and all of a sudden there's no insurance on the property, right? So you really don't want to get caught in that situation. You may also be called upon to deal with any sort of Social Security, Medi-Cal, or Medicare issues, any other public benefits. And so those are some capacities you may also be stepping in. You might also be required to or may need to look into hiring caregivers to take care of or make sure that the principal is well taken care of. And finally, arranging for rides and meal delivery and using the principal's funds in order to do that. So there's a lot of different wide sweeping potential powers that you could be called upon to exercise. And it's really important that you remember that when you're acting in the capacity as an agent, that you're always acting in the best interest of the principal. So you yourself can't use any of those funds for your own benefit, and it's really important that you review the document to see whether or not you can be compensated for your time. That is one thing that I failed to mention previously in the slides regarding whether or not to act as a trustee or as the executor. There's always the potential that you might be compensated for that time, and so it's really important that you review the trust to see whether you have compensation ability. Same thing with your power of attorney for finances or the Advance Health Care Directive. And then if you're acting as an executor, compensation is dictated by statute. And so that one, there's less flexibility about time actually spent, but that's a whole different discussion. All right. Let's see. Go back one slide. Perfect. Yep. So what's next if you're acting as the agent under an Advance Health Care Directive? First and foremost, you're going to want to review the Health Care Directive and decide whether or not you are willing to step into that position and accept the position as agent. Assuming that you are, the next step here would be to determine what the principal's needs are. So in this capacity, that might include coordinating with caregivers regarding any specific needs, accompanying the principal to medical appointments, assisting with picking up and maintaining medications, and then even assisting with decisions regarding care of the principal. And typically this is going to be surrounding treatment or withholding of treatment. And like I mentioned before, the Advance Health Care Directive itself is not a DNR necessarily. Now, the principal might have put some very specific instructions in place about what types of treatment or withholding of treatment or situations that where they either would or would not want care to be provided or for their life to be prolonged. But ultimately, you as the agent are, again, acting in the principal's best interest. And hopefully you would have talked to them or they would have talked to you during their time of capacity where they've told you what they would have wanted so that you have a good idea about if they were there and able to tell the doctors or healthcare providers what they want, that you're basically telling the healthcare providers something similar to what you think they would have wanted. One really important piece that I also want to mention is that whether it's the durable power of attorney for finances or the Advance Health Care Directive, because this is an agency type of capacity that you're acting in, you can only step in and act on behalf of the principal while the principal is still alive. And so largely, once they have passed away, your authority as agent then ceases to exist. And so any of these steps that you're taking, whether it's management of funds or management of healthcare, that's only really going to be effective during the principal's lifetime. The healthcare directive does have some post-death authority, but for the most part, when it comes to treatment or during life decisions, that's pretty much exclusively what you have authority to do. Okay. So we've kind of been talking about this throughout the presentation, but some general duties to be aware of, whether you're acting in any of these capacities, is you want to make sure that you're keeping really good records. You don't want to commingle any of your own assets with that of either the trust or the estate or the principal, because that could potentially be grounds for your removal in any of those capacities. You really want to avoid any conflicts of interest. So for example, in the hypothetical that we've been talking about, son would not want to make a distribution of assets of the trust to just himself and not his other two siblings. He'd have to treat everyone fairly and not only act in his own best interest in that situation. And he also potentially, let's say there's a house, he wouldn't want to decide as trustee to abuse that position and, for example, sell the house to himself for pennies on the dollar, because that would be to the detriment of the other beneficiaries. So really important that you're acting very neutrally and avoiding any conflicts of interest. And I promise that it's not self-serving, but I highly recommend that you consult with an attorney just to make sure that you understand very clearly what the specific guidelines are that you need to be following, because every situation is different. Right. Everything we've been talking about today are really general guidelines about things that you want to be aware of, but each situation is going to be really different and very unique to all the different parties that are involved and the assets that are involved and the needs of the person who you're serving or the documents that you're acting on behalf of. I do want to say also that whenever you see or know that you've been nominated in any of these capacities, right? Let's say trustee, executor, agent under DPOA or healthcare directive, you really want to consider whether or not you want to accept that position. And the reason why I say that is because it's a lot of work. I have clients who come in and they don't quite realize how much time they're going to be spending. And maybe they themselves have a family, a full-time job, other people who are dependent on them. And so when you're stepping into any of these roles, you're really starting to take on a very, very big responsibility of not only understanding someone else's entire financial life, but then also potentially owing duties and responsibilities to additional people on top of that. And opening yourself up to potential liability in case you do anything incorrectly. And so I've talked about compensation in the past, but part of the calculus that a lot of people also look into in hypothetical situation with mom and son, for example, let's say even if the trust said that son could get compensated for his time, a lot of times I do have those clients come in and say, well, I don't think it'd be right for me to take the compensation. And I always tell them, if the documents let you or allow for the compensation, just keep track of your time, because you really won't realize how much time you're expending until you get to the end of it and you realize you put in hundreds of hours, to the detriment of your own personal life or your family life, if that's the case. So it's not necessarily an honor to be designated in any of these capacities. And by all means, if you're the only person in the family who is capable, willing, or available for the principal or the person who's created the document, then of course, if you want to take on that responsibility, then that's absolutely fine, and you can accept that position. But just know going into it that it's a lot of work, and yeah, so just a little forewarning there. There are some alternatives that people can consider, which are professional fiduciaries. And in fact, I will be coming back next Wednesday at 4 o'clock for a presentation with a California licensed professional fiduciary. Her name is Shannon Downs. And so I'll be coming back, and she'll be explaining some of her experiences as a professional fiduciary and explaining generally what types of services she provides, and can kind of act as that neutral third party for someone, rather than having a family member, or maybe if a family member is not able or willing to step in and act in any of the capacities that we've been talking about today. So yeah, as you can see on the slide, that's coming up on Wednesday, March 23rd at 4 p.m. So you can sign up with ACC, and I might see you on there. So that's really it for today. I will open it up for some Q&A from anyone if you're interested. I will say that if you have any really specific questions about a certain situation that you yourself are experiencing as a trustee, executor, or agent, I do recommend that you contact me for a consultation, because each situation is really different and I might need a little bit more information. But if anyone has any general questions, then we can definitely open up the floor for that. Okay. Oh, no questions so far? Okay, I'm sorry. I probably threw a ton of information at you guys too, but if anybody does have any other questions, feel free to reach out. And I believe that the slides will be available as well to anyone who's attended. So yeah, you can go back and take a look as well. So thank you all for attending. And if you have any other questions, oh, I think someone just typed in a question. So let's hang on for just a second. Sorry, bear with us for just a sec. Oh, perfect. Okay, so the question is, if there are heirlooms or even trinkets that are not listed in the trust, does the trustee determine where they go? That's a really good question. So some trusts are specific as to personal property, and there may even be a separate memorandum that the settlor, grantor, trust maker left behind. But in the event that there is no specific instructions, or there are no specific instructions about that, then generally we look to the distribution language of the trust. And if, for example, it just says equal shares, right, the hypothetical we've been talking about, mom says equal shares of any and all assets left at my death to my 3 children, then the trustee would need to, if they want to be very formal about it, they would inventory all of the personal property. And if they had an estate sale, for example, they would need to divide up all the proceeds evenly between or among the beneficiaries. Oftentimes, though, if the trustee and the beneficiaries are all on the same page about personal property items, especially if they're sentimental items or heirlooms, then it makes sense to let them just handle that informally and just meet up at the house and all decide on, what they all are okay with each person receiving. So it just depends on how formally they want to handle it and whether or not there are specific instructions that were left behind in the trust. Okay. All right. Well,
Alice, could I ask a question about kind of along those lines?
Sure.
If there are a number of pieces of personal property and they are designated for persons who do not live in the area, live in other parts of the country, and are and those people are not known by the trustee except the name and all that information. And those people are not aware that they're going to receive these items. It's possible, I guess, that they might not choose to have them if it, needs to be shipped and so forth. Do you recommend that when possible, they be asked ahead of time, the recipients, and kind of make that decision ahead of time, so it's not the agent or whatever the correct term is, executor or whatever, and there may be a second and third choice listed. I'm not sure about that, but that you that the person who is alive could find out if they in fact want this.
Yeah, I think that's a really good question. So open communication is really important. I would say that if the person who created the trust is still alive, they may want to reach out to that intended potential beneficiary during lifetime to see whether they're even interested in receiving it. If the person has already passed and now the trustee has stepped in and they have no idea who any of these people are, no idea how to contact them. Now, they do have a duty to try to locate them and make a reasonable effort in locating them. Normally, this would be something I would do is a public record search of the name and any other identifying information that might have been left behind for that beneficiary. But if it turns out that you can't locate them and you don't know where they are at all, then the trustee will have made a reasonable effort to reach out, and I think they would have met their duty to do so. Now, if they did find out who that beneficiary was, they were able to contact them and they told them what they're supposed to receive, and the beneficiary says, "Oh, thanks, but no thanks," then the trustee can just send out a waiver or some sort of acknowledgement in that case to the beneficiary, saying that they understand that they could be receiving this item, but that they declined to receive it. Another situation that has come up before is, well, let's say that beneficiary really does want the asset and they live in another country or all the way across on the other side of the country. The trust itself would be responsible for paying for the shipping costs to get that over to the beneficiary. And so the trustee would just work directly with that beneficiary for the means that, I guess, the most reasonable means of getting the item over to them.
Yeah, thank you.
You're welcome. Okay. Well, yeah, thank you everybody for attending. And like I said, if you have any questions, feel free to reach out. And if not, then I might see you all back on next week. All right, thank you.